been causing thousands of victims and giving rise to massive war crimes and a risk of genocide, as you recognized in your order of 26th of January. We condemn with the same force the crimes committed by Israel, the occupying power, and the settlers in the West Bank and in the city of Al-Quds al-Shari. We denounce the refusal by Israel, the occupying power, to end its illegal occupation of Palestinian territory, as well as the multiple violations of norms of international law brought about by this continuing occupation, and we deplore the inability of the Security Council to uphold international law, to halt this spiral of violence, and to render justice to the Palestinian people. Mr. President, members of the court, it is against this backdrop that we recalled that a just, lasting and comprehensive peace based on the two-state solution is the only way of ensuring the security and stability of all peoples in the region and protect them from the cycle of violence and war. In the same spirit, we ask that all countries cease exporting arms and munitions to the occupation authorities, knowing that the army and the settlers are using them against the Palestinian people. On this occasion, we took pains to denounce all forms of hatred and discrimination and all assertions that enshrine the culture of hatred and extremism, and we proclaim the imperative for the international community to take immediate and swift measures to end the massacre and the targeting of Palestinian civilians, so as to confirm that there's no difference between one life and another, nor discrimination on the basis of nationality, race, or religion. Those are the conditions without which no lasting peace is possible. We also expect your court to condemn the accelerated colonization of East Jerusalem, as well as the Israeli attacks conducted against Islamic and Christian holy places at Al-Quds. So therefore, we hope that the advisory opinion you will render will be an opportunity to recall under your authority the imperative duty incumbent on Israel, the occupying power, to end its occupation of Palestinian territories prolonged for far too long, and to repair all the consequences. And now our counsel, Madame Chemillé-Gendreau, to whom I respectfully ask you to give the floor, Mr. President, will set out the legal aspects on which the Organization of Islamic Cooperation believes it can provide some further clarification. Thank you.
Yes, thank you very much, Mr. Taha. I now invite Madame Monique Chemillé-Gendreau to the podium. You have the floor, Madame. Yes, thank you. Thank you, Madam, Mr. President. It's on behalf of the Organization of Islamic Cooperation that I have the honor to appear before you this morning. I'm going to look at three elements of the situation which lie at the heart of your opinion. Now, some of the participating states in the instant proceedings requested your court to decline your jurisdiction. They were of the opinion that the request for an opinion would upset the negotiations purportedly underway between the protagonists, and these negotiations were the only way towards peace. But let's have a look at the facts. Let's establish them in their truth, because that's an indispensable condition for justice to prevail. Now, are there negotiations underway between Israel and Palestine? The truth of this question is that there aren't any more. This is a myth which has long been artificially maintained, but which if you look at current events, has totally collapsed, and even the parties involved admit this. Is the court in a position to establish truth on this point? Now, some participants in the instant proceedings have argued that you should decline your jurisdiction on account of some supposed difficulty to access the facts. But the case file that you received from the services of the UN themselves have all the elements you need on which to base the opinion requested. Thus, it is a known fact that the Oslo Accords, dating back to 1993 and 1995, that their objectives were intended to be achieved by 1999 at the latest, and that this time frame has not been met, and that subsequent meetings held in Sharm el-Sheikh in 1999 and Cape David in 2000 bore no fruit. From then on, neither the redeployment of Israel nor the consolidation of the Palestinian Authority's autonomy has come to pass. The outlook for the Oslo Accords hinged on compliance with resolutions 242 and 338 of the Security Council, where they are explicitly mentioned. This compliance required the withdrawal by Israel from occupied Palestinian territory in 1967. Article 18 of the Vienna Convention on the Law of Treaties provides that parties to an agreement must abstain from acts which deprive the treaty of its object and purpose. Thus, Israel's accelerated settling of Jewish colonies on Palestinian territory has deprived the Oslo Accords both of their object and of their purpose. Israel's politicians have confirmed the demise of negotiations when they denounced the Oslo Accords as of the year 2000. That's more than 20 years ago. At that time, Ariel Sharon declared to the Haaretz, I quote him, "We're not going to continue Oslo, no more Oslo, Oslo, it's finished." End of quotation. More recently, on 12 December 2023, Prime Minister Benjamin Netanyahu asserted, I'm quoting him, "I shall not allow Israel to repeat the mistake of the Oslo Accords." End of quotation. Your court will recognise that we are confronted here by a particularly noteworthy breach of good faith. Israel is a member of the United Nations. It's bound by the resolutions of this organisation as well as by specific undertakings it made. Yet it rides roughshod over the entire body. The state in question appropriates Palestinian territory, expels its people, denies Palestine the right to self-determination by all means available. You recalled in your judgment of 2018 that when states engage in negotiations, I quote you, they must conduct them in good faith. End of quotation. Well, it would appear that Israel's good faith vanished shortly after engaging in the Oslo negotiations. Thus, no negotiation on the horizon right now which needs protection. Just an ongoing war and the refusal of Israeli authorities to open any political perspective based on international law. That's why the argument whereby a finding of jurisdiction to give this opinion would in some way bar the way to a negotiated peace is an argument wholly without merit. Now, this is my second point. I'd like to dwell a little longer on the question of negotiations to make a substantive remark here. Palestinians will not recover their legitimate rights by direct bilateral negotiations with Israel, and there are two reasons why not. The first relates to the overwhelming inequality between the two parties. Palestine is under Israel's military domination, and its representatives find themselves in a position of structural weakness. As such, any negotiation will be biased, and the resultant treaty will necessarily be unbalanced. The second obstacle relates to the fact that in negotiations which have taken place up to now, Israel has attempted to make the Palestinians make concessions to the fundamental rights they have under international law. The principal violation, which is the source indeed of the other violations, lies in Israel's persistent refusal to let or to give the Palestinian people the right to self-determination. At no moment since the end of the British mandate in 1947, has Israel's leaders admitted with sincerity that a Palestinian state could coexist with them in Palestine. Israel's Prime Minister confirmed this on 20 January to his opposition to any Palestinian sovereignty. When Israel pretended to negotiate the Palestinians' right to statehood, it was only to concede a caricature thereof, demilitarized power, enclave, dispersed over a fragmented territory with reduced access to its own natural resources. And yet, the right of peoples to self-determination is a just Kogan's norm. It is not some constitutive right which could only arise if recognized by Israel. Not at all. It's a declarative right, inherent to the situation of the colonized people of Palestine. And it exists from the moment this people, the Palestinian people, decided to claim it. Thus, purely and simply, this is not a negotiable right. Israel has occupied, as of 1967, Palestinian territories subsequent to a military action which was carried out in breach of the core rule prohibiting the use of force. So Israel is occupying a territory over which it has no right. Israel must withdraw. And that's not negotiable either. By colonizing this territory, Israel breaches the prohibition of transferring population from the occupying power into the occupied territory. And Israel's official plan is to continue this unlawful act. From the 700,000 currently on the West Bank and in Jerusalem, the settlers should pass the million number as fast as possible, according to Minister Smotrich. That's what he said on 12 July 2023. So Israel has officialized this breach by including in its basic law of 2018 the development of Jewish settlements as a basic value of Israeli society. This, notwithstanding that international law requires the dismantling of all these settlements. And here, yet again, we have before us an obligation which is non-negotiable. The security of Palestinians is seriously threatened. They're dying in thousands under Israeli bombs in Gaza since 7 October, and in the West Bank, according to Israeli sources, 367 Palestinians have been killed since 7 October, including 94 children. 2,960 Palestinians have been arrested, and Palestinian sources are of the opinion that these figures are highly underestimated. Settlers in the West Bank and East Jerusalem freely wreak violence against the Palestinians. They're encouraged. They are armed by the state of Israel itself. So the dispossession of their lands and the repression to which the Palestinians are subject to has intensified over the last months, and at the same time a policy of discrimination which constitutes apartheid. All these violations of fundamental rights must stop. Once again, it's not negotiable. To give the requested opinion, your court will have to look at the question of Jerusalem. Now, this city wasn't included in the territory destined to Israel by Resolutions 181 of the General Assembly of the UN, proposing a partition plan for Palestine. When it was admitted to the UN in 1949, Israel solemnly accepted the principles of the UN Charter and the resolutions voted by its organs. Thus, there was recognition that Jerusalem had not been attributed to Israel. However, by taking over the west part of the city by force in 1948 and in 1967 the east part of the city, Israel made Jerusalem its reunited capital in 1980. Since then, East Jerusalem has undergone a forced Israelization via intense settlement. This is considered as irreversible by Israeli leaders. However, East Jerusalem has no other status than that of a territory occupied militarily by foreign power, and like all, indeed, of Palestinian territory occupied since 1967. So Israel has to withdraw in favour of the Palestinian people, as the relevant resolutions of the Security Council and the General Assembly have required constantly. The holy places have to be freely preserved and open to all those who wish to go there. And that's not negotiable either. Disregarding these legal imperatives shared by all nations, Israel would like to legalize its unlawful actions, which I've just mentioned, by placing them in an agreement. Yet if one subjects the situation to legal analysis, what becomes apparent is that Israel has no right over Palestine, only duties, and the preservation of international public order based on shared, non-derogable norms depends on their being complied with. The responsibility of this compliance falls to the United Nations, which is mandated with peacekeeping. They have been confronted with Palestine's decolonisation case file by the failure of the mandate given to the UK. The UN is the only authority capable of resolving on a legal basis the situation created by decades of failure. And if peace must come from an agreement between the parties, this must be concluded under the auspices of the United Nations, guarantors of legal compliance, and not under the arbitrary sponsorship of a third state lacking in objectivity. Thus, the way forward, based on the findings of your opinion, should ensure that the agreement re-establishing the Palestinians in all their rights will respect the fundamental norms which currently are the target of circumvention. If that weren't to be the case, the future peace treaty would fall under the Vienna Convention of the Law of Treaties, which provides, I quote, "A treaty is void if at the time of its conclusion it conflicts with the peremptory norm of general international law." End of citation. This brings me to my last point, the second question, which is being put to your court by the General Assembly of the UN. You are asked about the legal status of the occupation and on the legal consequences arising from it. You must thus examine Israel's occupation of Palestinian territory holistically in the light of international law. Well, first of all, it's jus ad bellum, the law which governs the use of force by states. This includes the very important norm of the prohibition of the threat of use or use of force against the territorial integrity or political independence of any state. Now, it is established that it is by the use of force that Israel occupied Palestine in 1967, as the Security Council and the General Assembly have ceaselessly recalled. This use of force directed against territorial integrity and Palestinians' political independence, which is today recognized as a state by the UN. So the occupation was unlawful from the very beginning. This illegality is manifest since 1967 by the way in which this occupation has been conducted. It breaches all the conditions set out in the law of The Hague and Geneva regarding military occupation of foreign territories. These conditions are identified by the manual of the International Committee of the Red Cross. The occupying power may not modify the structure and characteristics, intrinsic characteristics of the occupied territory over which it acquires no sovereignty. Israel has ceaselessly changed these characteristics for its own benefit. Occupation is and should remain a temporary situation. Now, Israel's been occupying Palestine for 66 years now, and its leaders openly broadcast their intention to indefinitely pursue this occupation. Israel must administer the territory in the interest of the local population, taking into account its needs, and the needs of the Palestinians have been cruelly ignored. Israel must not exercise its authority to serve its own interests and those of its own population, yet all of Israel's policies and practices are directed for the benefit of Israeli settlers and in breach of the Palestinians' rights and interests. These are the conditions in which Israel has developed the occupation of Palestinian territory, conditions whose complete evidence can be found in UN reports. And they will lead you to conclude that this occupation, by its duration, by the practices of it, is the pretext for an annexation plan. This, officialized regarding Jerusalem, has been implemented de facto for the West Bank. Well, as for Gaza, total war underway there, and the plans announced by the government of Israel confirm the will of Israel to maintain their mastery over this territory. The result of all this, as your court doubtless will confirm, is that the occupation by Israel of Palestinian territory is triply unlawful. It is unlawful at its source, having breached the prohibition of the use of force. It is unlawful on account of the means used, which constitute systematic violations of humanitarian law and human rights law. It is unlawful by its aim, objective aim, being to annex Palestinian territories, thus depriving the people of Palestine of its fundamental right to self-determination. I'd now like to just give you a few of my reflections to conclude. Israel's unjustified and unpunished use of violence against the Palestinians leads to yet more violence in response, in an infernal cycle, that of vengeance. And vengeance naturally favours the strongest. This is the murderous chain of events tragically taking place as we watch. To break this chain, an impartial third party is needed, authoritatively asserting what the application of a common norm should be. It falls to your court, when you hand down this opinion, to bring all of this conflict back under the spotlight of the law. This law allows you to declare what rules should be applied in a critical situation, but also what measures can be taken when these rules are persistently violated. Let me recall that the submissions of the Organization of Islamic Cooperation remain unchanged with respect to our written comments, but I will allow myself, if that is all right, to refer to two of them. I recall solely that the organisation that I represent requests the court to enjoin Israel to cease the violations which have been pointed out. and to require the UN and their member states to use all measures available to bring the situation to an end, including sanctions against the responsible state. In peroration, Mr. President, distinguished members of the Court, I'd like to quote Israeli Rear Admiral Ami Ayalon, who ran Israel's domestic intelligence service for a number of years. Now, his personal path in life has led him to question the concept of the enemy and assess the dead end in which Israel finds itself after having chosen violent repression to accompany its refusal of a political solution. A few weeks ago, he concluded an interview given to a French newspaper by saying, I'm quoting him now, "The international community should play a beneficial role. We need someone from the outside to show us our mistakes." End of quotation. So, saving the Israelis from themselves, that will be the contribution of the international community, thanks to your advisory opinion. Thank you very much for your attention.
I thank the delegation of the Organization of Islamic Cooperation for its presentation. I invite the next participating delegation, the African Union, to address the court and call Madam Professor HAGUE to the podium. Madam, you have the floor. Mr. President, distinguished members of the court, it's an honor for me to represent the African Union, an organization numbering 55 member states, on this last day of pleadings within the framework of the present advisory proceedings. It's important to recall the historical context and the tragic circumstances that prompted the UN General Assembly to request once again and regrettably for the international community an advisory opinion from the court on the situation of the occupied Palestinian territories. Now, the history of Palestine is a history of dispossession, displacement, and of dehumanization. It's the history of an injustice. It's the tragedy of a people who, for over 7 decades, is systematically subjugated and oppressed by the Israeli colonial project, whose aim is to establish total and exclusive control on all of Palestine's soil, to deny the Palestinian people its inalienable right to self-determination and deprive it of its right to live freely in its native land. The ongoing Israeli aggression against Gaza demonstrates this tragedy. A population of over 2 million innocent and defenseless civilians is the victim of a campaign of wanton death and destruction, consequence of the collective punishment exerted by the occupying power for decades. That's why at the conference of heads of state and government of members of the African Union that was held on 17 and 18 February this year, the heads of state and government of member states of the AU expressed, and I quote, their total outrage at the humanitarian catastrophe caused by Israeli forces occurring in the Gaza Strip and their full support for the Palestinian people in their legitimate struggle against Israeli occupation. The heads of state and government of member states of the AU also denounced, and I quote, the collective punishment measures against civilians, especially the attempts to forcibly transfer the Gaza population. Consequently, Israel's aggression against Gaza is nothing but a shameful attempt to create another Nakba, a further catastrophe destined to erasing the Palestinian presence in Palestine. Indeed, barely a few weeks ago, this court recognized the grave peril that the Palestinian people was facing in Gaza when it determined that South Africa, one of the member states of the African Union, had established the plausibility of its allegation according to which Israel is committing genocide. Nothing can justify the unspeakable suffering and horrors inflicted on the population of Gaza. That is the essence of the Palestinian tragedy. For over a century, the Palestinian people is enduring a succession of Nakbas, from the Balfour Declaration to the wars of 1948, 56, 67, and 82, with the establishment and expansion of Israeli settlements and the construction of the separation wall. At every moment of history, the Palestinians have been the victims of subjugation, displacement, and dispossession. The escalating violence and the ruthless war machine are ceaselessly devastating the Palestinian population. Schools, places of worship, homes, hospitals are reduced to nothing, leaving behind them only the smoke of bombs that continue to rain down on Gaza. By miracle, children are born under the rubble, but they're living on borrowed time, given the famine affecting them, grieving families, surviving without water, without electricity, and see day after day their hopes, their dreams, and their destiny despairing forever under the ruins. The conscience of humankind will never forget it. Mr. President, members of the court, this advisory proceeding aims at preventing this new injustice resulting not just from the force of arms, but also Israeli practices comprising the de jure and de facto annexation of Palestinian territories, the illegal establishment of settlements, the alteration of the demographic character of Jerusalem, and then the confiscation and destruction of Palestinian property, expropriation of Palestinian land, the construction of bypass roads, and maintenance of the separation wall. The fact that these Israeli practices in occupied Palestinian territories are continuing and accelerating is the result of the impunity that Israel enjoys and its breach of the right of people and the jus cogens norms that are enforceable erga omnes. This contempt is illustrated by the Israeli decision to ignore the advisory opinion of this court regarding the separation wall, or the countless resolutions passed by UN organs that have documented these violations of international law. This instant advisory proceeding is an opportunity to at last hold Israel accountable for its acts, but also to put an immediate end to its impunity and to uphold general international law, international humanitarian law, and human rights law. Furthermore, the African Union is a party to this proceeding because it feels it has a particular responsibility towards the Palestinian people. Its member states emerged from this colonial scourge, waged war against apartheid and racial discrimination, and defended the cause of self-determination. Our presence here today reflects the sentiment expressed by heads of state and government of African Union member states who stressed, and I quote, the centrality of the just cause of Palestine and the steadfastness of our supportive position and decisions based on our shared values against colonialism, oppression and apartheid, and the historically established African solidarity with the Palestinian people in their legitimate quest for freedom and an independent state. Mr. President, members of the court, on the occasion of the advisory opinion of the court on the Chagos archipelago, the African Union saw the authority and impact of the court's decisions. This opinion indeed contributed to almost ending one of the last living forms of colonialism in Africa. As with this case, the question before you doesn't hinge on a dispute opposing two equal parties, but an asymmetrical situation in which an oppressed people is confronted with an occupying power. Therefore, the court will be able to confirm, in the same way as in the Chagos case, the Palestinian people's right to self-determination and freedom, and ensure the state of Palestine is in a position to exercise its full sovereignty and its independence on its territories of the West Bank, Gaza, and on its capital, East Jerusalem. Before humbly asking the court to give the floor to my colleague, Professor Mohammed Helal, I'd like to address the question of jurisdiction. Our observations will be brief. The vast majority of participants agreed that this instant proceeding, that nothing prevents the court from exercising its advisory function. It's a position that the African Union shares fully and totally. Indeed, the court has already confirmed its jurisdiction in a request for an advisory opinion on the same factual situation in the Wall opinion, and it has no reason to divert from that assessment. Furthermore, the jurisprudence of the court has affirmed on numerous occasions that the political nature of a dispute has no incidence on the duty of the court to answer the questions of a legal order put to it by the General Assembly. Moreover, the court has abundant evidentiary material and facts available to it, allowing it to render an advisory opinion. Lastly, the existence of a negotiating process cannot justify by the court the use of its discretion not to render said advisory opinion. And contrary to the statements by certain parties, the opinion of the court, far from complicating this process that's in fact at a stalemate, can but strengthen it by clarifying the obligations and legal consequences for all parties. In concluding, I should like to recall the words of Nelson Mandela a few years after the liberation of South Africa. He issued a warning which concerns us all, and I quote,
"Even our own freedom, we can fall into the trap of washing our hands of difficulties that others face, yet we would be less than humans if we did so."
And it is in this spirit that he spoke the words that continue to resonate in the streets of the whole world today.
It's incomplete without the freedom of the Palestinians.
Mr. President, I now ask you to kindly give the floor to my colleague, Professor Mohammed Helal. Thank you for your kind attention.
Je remercie Madame Geldich. I now give to Mr. Mohammed Helal. You have the floor, sir.
Thank you. Mr. President, distinguished members of the Court, it is a privilege to appear before the Court on behalf of the African Union. As indicated by the Legal Counsel of the African Union, I will cover the following issues. I will identify the internationally wrongful acts that are attributable to Israel and address the question of the legal status of Israel's occupation of the Palestinian territories. Second, I will address the question of whether there are circumstances precluding the wrongfulness of acts that are attributable to Israel. And third, I will outline the legal consequences arising out of these internationally wrongful acts. The point of departure for determining the legal status of Israel's occupation of the Palestinian territories is the question of title. Does Israel have title over the West Bank, Gaza, and East Jerusalem? The answer is unequivocally no. Given time constraints, I will only identify the main milestones of Palestine's history. Palestine was under Ottoman sovereignty, and it came under British belligerent occupation during World War I. Then, in 1922, Palestine was placed under a League of Nations mandate that provisionally recognized Palestine as an independent nation under British administration, after which Turkey renounced sovereignty over Palestine pursuant to the 1923 Treaty of Lausanne. This was followed in 1947 by the adoption of the Palestine Partition Plan, which was never implemented. And then in 1948, Britain withdrew from Palestine and Israel unilaterally declared independence, which was followed by armistice agreements in 1949 and the establishment of Egyptian control over Gaza and Jordanian control over East Jerusalem and the West Bank. And finally, in 1967, Israel launched an armed attack, as a result of which it occupied the West Bank, Gaza, and East Jerusalem. At no point in this process did Israel acquire title over these territories. Moreover, theories that support an alleged Israeli title over these territories, such as the claim that the legal status of Palestinian territories was indeterminate, or that there was a sovereign vacuum that Israel was entitled to fill, are entirely unfounded. Accordingly, since 1967, Israel has exercised belligerent occupation over the West Bank, Gaza, and East Jerusalem. The African Union also submits that Israel's 57-year occupation of the Palestinian territories is unlawful and must be brought to an end. This determination is based on three arguments. First, as the overwhelming majority of parties in these proceedings have argued, Israel's occupation is unlawful because it violates the prohibition on the acquisition of territory by force, which is a corollary of the prohibition on the use of force. This constitutes a violation of a peremptory rule of international law. The evidence on this point is incontrovertible. Pronouncements by Israel's political leaders and the conduct of Israel on the ground reflect an intention to perpetuate the occupation through acts that amount to de jure and de facto annexation of Palestinian territories. Israel's conduct in the current hostilities in Gaza also demonstrates its goal of entrenching its occupation of Gaza. Israel is reportedly planning to establish permanent buffer zones, maintain a long-term active military presence on the ground, and is striving to displace the population of Gaza to neighboring states. This conduct, which has been roundly denounced by the African Union, confirms Israel's intent to acquire and annex further Palestinian territory in Gaza. Second, also as the overwhelming majority of parties have argued, Israel's occupation is unlawful because it deprives the Palestinian people of their right to self-determination. It is uncontested that the Palestinians are a people that are entitled to exercise self-determination. It is also established that self-determination is a right that is exercised in relation to a specific territory, and that it is unlawful to disrupt the unity and integrity of the territory in relation to which the right to self-determination is exercised. In the present case, the territories on which the Palestinians are entitled to exercise self-determination are the West Bank, Gaza, and East Jerusalem, which constitute a single, indivisible territorial unit. Violating the right to self-determination also constitutes a violation of a peremptory rule of international law. Third, the cumulative effect of Israeli policies and practices that are associated with the occupation provides an additional basis on which to conclude that the occupation is, as a whole, unlawful. This is a point that deserves to be highlighted because it has been argued that violations of the law of belligerent occupation do not affect the legal status of the occupation. Specifically, the United States claimed, and I quote, that international law does not provide for an occupation itself to be rendered unlawful or void based either on its duration or on any violations of occupation law. This view is incorrect. The violations of international law committed by Israel in the occupied territories constitute continuing and composite breaches of international law. Specifically, Articles 14 and 15 of the ILC Articles on State Responsibility provide a basis for establishing that separate and distinct violations of the law of belligerent occupation can, when combined and viewed cumulatively, lead to the conclusion that the occupation as a whole is unlawful. Article 14.2 of the Articles on State Responsibility defines a continuing wrongful act as one that continues in time and remains not in conformity with an international obligation. According to the ILC, examples of a continuing wrongful act include, and I quote, the maintenance by force of colonial domination and unlawful occupation of part of the territory of another state. This confirms the relevance and applicability of this concept to the case of Palestine. Other examples of Israeli practices amounting to continuing breaches include settlements in the West Bank and East Jerusalem, the separation wall, the network of bypass roads, legislative acts purporting to annex portions of the Palestinian territories, and the exploitation of water resources in the West Bank. In addition, internationally wrongful acts that are attributable to Israel should be viewed as composite breaches of international law. As defined by Article 15 of the Articles on State Responsibility, composite acts are made up of a series of actions or omissions defined in aggregate as wrongful. This does not exclude the possibility that every single act in the series could be wrongful in accordance with another obligation. As the ILC explained, the concept of composite breaches is intended to address situations where the responsible entity, including the state, adopted a systematic policy or practice, and that is precisely why the concept of composite breaches is valuable in the present case. It captures the fact that Israel's conduct is not composed of random or isolated wrongful acts. Israel is pursuing a systematic policy that is designed to perpetuate its control of the Palestinian territories. For example, the establishment and expansion of Israeli settlements and the transfer of over 700,000 Israeli settlers to the occupied territories is wrongful under Article 49 of the Fourth Geneva Convention. Similarly, the construction of a bypass road is wrongful under Articles 46 and 52 of the 1907 Hague Regulations and Articles 49, 52, and 53 of the Fourth Geneva Convention. However, in addition to violating these specific rules of international law, the settlements, the bypass roads, and the separation wall and other practices are elements of an Israeli policy through which it is seeking to gain permanent control of the occupied territories, making it impossible to restore the status quo ante bellum. These Israeli practices, when viewed in their totality, make the occupation unlawful because they constitute composite wrongful acts that violate the prohibition on the use of force, the prohibition on the acquisition of territory by force, the prohibition on systematic racial discrimination, and the Palestinians' people's inalienable right to self-determination. Mr. President, distinguished members of the Court, I will now address the question of whether there are circumstances that preclude the wrongfulness of Israel's conduct. Specifically, I will argue that Israel cannot validly invoke the right to self-determination, the right to self-defense to justify its occupation of the Palestinian territories. In this regard, the historical record is unequivocal. Israel's occupation of the Palestinian territories was a result of an act of aggression that commenced on June 5, 1967. Moreover, it should be recalled that international law does not recognize a purported right of anticipatory, preemptive, or preventive self-defense. The terms of Article 51 of the Charter are unambiguous. The right to self-defense is triggered, quote, if an armed attack occurs, end quote. Indeed, the Organization of African Unity declared on numerous occasions that Israel's use of force in 1967 amounted to an act of aggression. It should also be recalled that in the Wall opinion, the Court determined that Article 51 of the Charter has no relevance where the alleged threats invoked by Israel to justify its conduct originate from within, not from outside the occupied territories. And even if one were to assume, arguendo, that Israel may invoke the right to self-defense as a circumstance precluding wrongfulness, which it cannot, it is patently clear that self-defense cannot justify Israel's practices. Self-defense is a narrowly construed exception to the prohibition on the use of force. Israel's practices that are designed to perpetuate its occupation can never satisfy the requirements of necessity and proportionality. Furthermore, as several states have already affirmed in their pleadings, the exercise of self-defense can never provide a valid basis for acquiring title to territory that is occupied as a result of the exercise of the right to self-defense. Moreover, given that many of the internationally wrongful acts attributable to Israel are violations of rules of jus cogens, it is our submission that self-defense cannot be invoked in this context. Article 26 of the ILC Articles on State Responsibility and Article 18 of the ILC Conclusions on Identification and Legal Consequences of Peremptory Norms of General International Law are clear. Quote, where the responsibility of a state for a breach of a peremptory norm is invoked, the state against which the breach is invoked cannot excuse itself from responsibility by raising any circumstance that might ordinarily preclude its wrongfulness. In short, the African Union submits that Israel cannot invoke self-defense as a circumstance precluding wrongfulness. Finally, Mr. President, distinguished members of the Court, I will turn to the question of the consequences arising from these internationally wrongful acts. The ILC Articles on State Responsibility affirm the customary principle that, quote, every internationally wrongful act entails the international responsibility of the responsible state. It is on this basis that the Chagos opinion that in the Chagos opinion, after the Court determined that the United Kingdom's continued administration of the Chagos archipelago constituted a wrongful act, it was held that the United Kingdom was under an obligation to bring an end to its administration of Chagos, quote, as rapidly as possible, thereby enabling Mauritius to complete the decolonization of its territory consistent with the right to self-determination. The same is required here. Israel must end its unlawful occupation of all the Palestinian territories as rapidly as possible in order to enable the Palestinian people to exercise their fundamental right of self-determination. This is the request that the majority of parties participating in these proceedings have made. The United Kingdom, however, is a notable outlier on this point. It argues that if the Court were to address the status of the occupation and require Israel's withdrawal, that would undermine the Security Council's framework that is premised on reaching a two-state solution through a process of negotiations. The African Union does not agree. To condition the end of occupation on a negotiated settlement is to make the occupation permanent given that the occupying power, Israel, refuses to negotiate on the basis of the two-state solution. And it has declared its will that it will never accept the establishment of a Palestinian state. Those states that purport to support the two-state solution ought to endorse calls for this court to unequivocally determine that Israel's occupation of the Palestinian territories is unlawful. This is especially necessary given the peremptory nature of the right to self-determination and the prohibition on the acquisition of territory by force. The modalities necessary to end the occupation as rapidly as possible could be decided under the supervision of the relevant organs of the United Nations. Israel's unlawful occupation of the Palestinian territories also gives rise to consequences for other states, including the customary legal obligations reflected in Article 41 of the Articles on State Responsibility, which are, 1, not to recognize any benefit accruing to Israel from the unlawful occupation, 2, not to lend aid or assistance to Israel that might further the occupation, and 3, to cooperate to end the unlawful occupation and to protect the right of self-determination of the Palestinian people. It is perplexing that the United States has challenged the customary status of Article 41. This long-established principle has been recognized by the court itself in the Wall Advisory Opinion and by the UN Security Council. It was even applied by the United States in 1932 in the context of the Japanese aggression against China in what was known as the Stimson Doctrine. Pursuant to this doctrine, the United States government declared that, quote, it cannot admit the legality of any situation de facto, nor does it intend to recognize any treaty or agreement that impairs the sovereignty, independence, or territorial integrity of China. The court should uphold this principle. In its written statement, the African Union offered various specific ways in which states may practically and meaningfully comply with these obligations of non-recognition, non-assistance, and cooperation. The African Union simply wishes to emphasize that occupation and self-determination cannot exist at the same place and the same time. If occupation is illegal, it must be ended to permit the recognition of self-determination. In closing, Mr. President, members of the court, the African Union reiterates its call to end Israel's occupation of the Palestinian territories. The injustice being wrought against the people of Gaza as we convene here in the Great Hall of Justice makes it imperative to end Israel's impunity and hold it accountable to the rule of law. The court of history may very well judge the credibility of international law on the basis of the outcome of these proceedings. The international community has let down the Palestinian people, but the African Union has faith that in this court, justice will prevail. The betrayal of the sacred trust that is the self-determination of the Palestinian people is an enduring injustice that pleads to be remedied. It is the only path towards ensuring a future of security, stability, peace and prosperity for the peoples of a troubled region. Thank you for your attention.
I thank the delegation of the African Union for its presentation. The court will meet again this afternoon at 3 p.m. to hear Spain, Fiji, and the Maldives. The sitting is adjourned. Please be seated. The sitting is open. The court meets this afternoon to hear Spain, Fiji, and the Maldives on the question submitted to it by the United Nations General Assembly. As the delegations are aware, they must keep to the 30-minute speaking time. I shall now give the floor to the Representative of Spain, Ms. Andrea Gavela Lopez. You have the floor, Madam.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. Spain, pursuant to the invitation by the Court in accordance with Article 66 of its Statute, presented a written statement on the 25th of July 2023. The current oral intervention aims to complete that written statement and furnish the Court with some elements that, from the Spanish point of view, may be of help in discharging the request made by the General Assembly. Spain, in this oral intervention, will amply rely on the advisory opinion rendered on July 9, 2004, on the legal consequences of the construction of the wall in the occupied Palestinian territory. As it is of the view that most of the Court's arguments and replies to be found in this opinion are of paramount relevance and are also applicable to the present case. We are going to address the Court in two main blocks. In the first one, we will briefly analyse the jurisdiction of the Court and then examine the international law applicable to the case, affirming that Israel is bound by this law. In the second one, we will elaborate on the particular issue of international responsibility of states in case of serious breaches of international rules that protect the basic interests of the international community as a whole. The second part will be dealt by Professor Mr. Ripoll Carulla, head of the International Legal Office, while the first part will be dealt by Mr. Emilio Pin, deputy head of that International Legal Office, to whom I kindly invite you to give the floor now. Thank you very much.
I thank Mr. Lopez. I now give the floor to Mr. Emilio Pin. You have the floor, sir.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. The competence of the Court to give the advisory opinion requested by General Assembly in its Resolution 77/247 is based on Article 65, paragraph 1 of its Statute. The General Assembly, which seeks the advisory opinion, is authorized to do so by Article 96, paragraph 1 of the Charter. The questions are directed to the legal consequences arising from a given factual situation, considering international law. It is indeed a question of legal character. Therefore, Spain is of the view that the Court has jurisdiction to give the advisory opinion requested by Resolution 77/247 of the General Assembly. The lack of consent to the Court's contentious jurisdiction by an interested state has no bearing on the Court's jurisdiction to give an advisory opinion. The goal of the request before the Court is to obtain from it an advisory opinion which the General Assembly deems of assistance to it for the proper exercise of its functions and responsibilities. Mr. President, distinguished members of the Court, both Israel and Palestine are under the obligation to observe the rules of international law. In the 1967 armed conflict, Israeli forces occupied all the territories that had constituted Palestine under the British mandate, including those known as the West Bank, located east of the Green Line. This occupation was immediately and unanimously condemned by Security Council Resolution 242, which underlined that, and I quote, all member states, in accepting the Charter of the United Nations, have undertaken to act in accordance with Article 2 of the Charter, end of quote. The principle of prohibition of the use of armed force is one of the fundamental principles of international law, and, as formulated in General Assembly Resolution 2625, is accompanied by the following corollary. I quote, "No territorial acquisition resulting from the threat or use of force shall be recognized as legal." End of quote. The Court, which has on several occasions affirmed the importance of this principle, has not hesitated to apply this principle to the Israeli occupation of the Palestinian territories. In the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territories, the Court has recalled the principle of the inadmissibility of the acquisition of territory by war. The Court concluded, and I quote, "Under customary international law, they were thus occupied territories in which Israel had the status of an occupying power." End of quote. Finally, the Court added, I quote, "Subsequent developments in these territories have done nothing to alter this situation. All these territories, including East Jerusalem, remain occupied territories, and Israel has continued to have the status of an occupying power." End of quote. Although Israel finally withdrew its civilian and military presence from the Gaza Strip in 2005, it has maintained full control of its borders, coastline, and airspace ever since. Consequently, as the Security Council has affirmed, the Gaza Strip constitutes an integral part of the territory occupied in 1967. The Court concluded that Israel's settlement policies in the OPTs, the measures taken with regard to Jerusalem, and the construction of the wall, I quote, "have been established in violation of international law." End of quote. Not only because they are contrary to the Fourth Geneva Convention, but also because they prevent the exercise by the Palestinian people of their right to self-determination. In its construction, the Court points out that the wall, the temporary nature of which is open to doubt, is accompanied by a regulatory regime aimed at annexing the occupied territories. This aim constitutes a serious violation of the rules of international humanitarian law incumbent upon Israel as the occupying power, has the effect of violating the right to self-determination of the Palestinian people and the human rights of the inhabitants of these territories. These statements are also applicable to the Gaza Strip. Israel's withdrawal from Gaza in 2005 has not meant that the occupation of the territory came to an end, and Israel has retained effective control over the territory through its control of airspace, territorial sea, and external land boundaries. The extensive documentation submitted to this advisory procedure demonstrates that 20 years after the Court's opinion, Israel continues to implement its policies, prolonging the very serious violations of international law found by the Court. Mr. President, distinguished members of the Court, on 3rd October 1991, Israel ratified both the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, as well as the United Nations Convention on the Rights of the Child. As stated by the Court, the protection offered by Human Rights Convention does not cease in case of armed conflict. Regarding the territorial scope of those instruments, they are applicable in respect of acts executed by a state in the exercise of its jurisdiction outside its own territory. That is, that they apply both to territories over which a state party has sovereignty and to those over which that state exercises territorial jurisdiction. Those elements concur in this case. Therefore, Spain considers that those instruments are applicable within the OPTs. As stated by the Court in its advisory opinion of 2004, the territories occupied by Israel have been now, for over 50 years, subject to its territorial jurisdiction as the occupying power. In the exercise of the powers available to it on this basis, Israel is bound by the provisions of human rights law and, furthermore, it is under an obligation not to raise any obstacle to the exercise of such rights in those fields where competence has been transferred to Palestinian authorities. Having determined the applicability of human rights law within the occupied Palestinian territory, it is time to seek whether Israeli policies and practices referred in paragraph 18A of General Assembly Resolution 77/247 have violated those rules and therefore have infringed the human rights of Palestinians living in the territory occupied by Israel. Among those rights that are being violated are those of Articles 17, paragraph 1 and 12, paragraph 1 of the International Covenant on Civil and Political Rights. Also, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967 has underlined in her latest report to the Human Rights Council that Israeli forces often detain individuals without charge or trial in what has been denominated administrative detention. Administrative detention is permissible only under very strict circumstances and must always be carried out in line with the protection afforded under international law. Palestinians in the OPTs are subject to a system of jurisdictional fragmentation in the context of a structure of institutionalized discrimination. Israeli military courts enforce military law upon Palestinians, while Israeli courts apply Israeli civil law to Israelis, including settlers. Regarding the International Covenant on Economic, Social and Cultural Rights, there are several provisions affected by Israel's policies and practices in the OPTs. For example, the right to work, protection and assistance accorded to the family and to children and young persons, the right to an adequate standard of living, including adequate food, clothing and housing, and the right to be free from hunger, the right to health, and the right to education. Similar provisions can be found in Article 14, 16, 27 and 28 of the United Nations Convention on the Rights of the Child. State parties to the Convention on the Rights of the Child, according to its Article 2, shall respect and ensure the rights set forth in it to each child within their jurisdiction. Of particular concern are the detention, interrogation, prosecution, and imprisonment of numerous Palestinian children by Israeli occupation forces, practice that is contrary to Article 37, paragraph B of that convention. Certain policies and practices of Israel in the OPTs impose restrictions on the freedom of movement of the inhabitants of the OPTs and deprive a significant number of Palestinians of their freedom to choose their residence, and have, as well, repercussions for agricultural production through the confiscation and destruction of agricultural assets. On the other hand, the population of the OPTs is experiencing increasing difficulties regarding access to health services, educational facilities, and sources of water, impeding the exercise by the persons concerned of the right to health, to education, to water, to sanitation, and to an adequate standard of living. All these difficulties and restrictions infringe a number of rights of Palestinians residing in the territory occupied by Israel, which cannot be justified neither by military exigencies nor by the requirements of national security or public order. Mr. President, distinguished members of the Court, the International Law Commission, in the report of its 73rd session, has referred to the basic rules of international humanitarian law as having the status of a peremptory norm of general international law, jus cogens, with the legal consequences that that status may entail. The provisions of the Hague Regulations, annexed to the Fourth Hague Convention of 1907, to which Israel is not a party, have become, nevertheless, part of customary international law. Particularly pertinent in the present case is Section 3 of those regulations, which concerns military authority over the territory of the hostile state. Furthermore, the Fourth Geneva Convention, to which Israel is a party, is applicable in any occupied territory in the event of an armed conflict, and, as the Court has assessed, it is applicable to the territories occupied by Israel since 1967, including East Jerusalem. Regarding Israeli settlements, Article 49, paragraph 6 of the Fourth Geneva Convention provides that, I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies." End of quote. It prohibits also any measure taken by an occupying power in order to organize or encourage transfer of parts of its own population into the occupied territory. Since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the OPTs, which are in contravention of the aforementioned Article 49, paragraph 6. Therefore, the Israeli settlements in the OPTs, including East Jerusalem, have no legal validity and constitute a flagrant violation of international law and a major obstacle to the achievement of the two-state solution, as stated repeatedly by relevant UN Security Council resolutions. The establishment of the Israeli settlements in the OPTs is tending to alter the demographic composition of that territory, contributing to demographic changes, all in contravention of Article 49, paragraph 6 of the Fourth Geneva Convention. The practice of demolitions results in the forcible transfer or forced eviction of Palestinians and impedes a de facto return of Palestinian families and communities to their original dwellings, all in contravention of international humanitarian law. Furthermore, in 2004, the Court considered that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case it would be tantamount to a de facto annexation, as well as a contribution to further alterations of the demographic compositions of the OPTs. Articles 47, 49, 52, 53 and 59 of the 4th Geneva Convention remain applicable to the OPTs and are to be taken into account in this case. Spain is of the view that neither Article 51 of the United Nations Charter nor the state of necessity have any relevance in this case in order to preclude the wrongfulness of those actions. Mr. President, let me now invite you to give the floor to Professor Santiago Ripoll, Head of the International Legal Office.
I thank Mr. Pinn, and I'll give the floor to Professor Ripoll. You have the floor, Professor.
Mr. President, distinguished members of the Court, what are the legal consequences arising from the repeated, permanent and aggravated non-compliance of core rules of international law? This is the question the General Assembly requested to the Court. When this question is examined from the perspective of the law of state responsibility, the importance of the advisory opinion becomes critical. Articles 40 and 41 of the 2001 draft articles on responsibility of states for internationally wrongful acts answer this question. According to these articles, a serious breach of an obligation established for the protection of the interest of the international community as a whole entails the legal consequences stipulated for all breaches of international law, and some particular consequences. Therefore, the responsible state is obliged to cease the wrongful act, to give, if appropriate, guarantees and assurances of non-repetition, and to make reparation. Moreover, the responsible state is bound to continue performance of the international obligation. On the other hand, failure to comply with international obligations gives also rise to the right for the injured state to seek redress or take countermeasures. However, it has been said, Article 41 states that besides these ordinary consequences, serious breaches of jus cogens rules gives rise to some additional particular consequences, which, generally speaking, imply certain obligations for all other states to respond to the wrongful act, namely, obligation to cooperate with and bring to an end the alleged violation, obligation not to recognize the legal situation, and obligation not to render aid or assistance in maintaining the situation. Mr. President, my intervention will focus on these particular obligations of all states, other than the injured states. In its 2004 advisory opinion on the war, the Court briefly referred to these additional consequences. 20 years later, with the worsening of the situation in the occupied Palestinian territories, the Court is called upon to set out in greater detail these obligations. Mr. President, distinguished members of the Court, the duty to cooperate to bring to an end remains the first obligation of the states, according to Article 41 of the draft articles. This obligation to cooperate shall be carried out by all states. In the Israeli-Palestinian conflict, cooperation among all states has been organized in the framework of the United Nations. Once again, 20 years after the advisory opinion on the wall was passed, it is an indisputable reality that the situation in Palestine has worsened and that resolutions of the Security Council and the General Assembly have repeatedly condemned the actions of the parties and repeatedly demanded the cessation of the violations of international law. However, such resolutions have failed to establish redress and sanction measures. Therefore, the reference of Article 41 to the action of all states becomes critical. In some way, paragraph 159 of the advisory opinion on the wall underlines this when this paragraph established that it is also for all states to take measures to end the breach. Moreover, in the comments to conclusion 19 of the draft conclusion on identification and legal consequences of parental norms of general international law, jus cogens, we can read that this statement suggests that over and above collective action, there is an obligation on individual states to make efforts to bring situations created by the breach to an end. In the current circumstances, maybe the Court could determine what such an obligation to cooperate might consist of in this case. In doing so, the Court may take into consideration the numerous resolutions of the Security Council and the General Assembly, especially those resolutions stating that states are obliged not to take measures that would imply changes in the status of the occupied territories, including East Jerusalem and the Gaza Strip. Corollary is clear. Establishing diplomatic missions in the Holy City is a serious threat to the stability of peace in the region and the world. Coming back to the cooperation of all the states within the bodies of the United Nations, the Court could determine whether the obligation of all states to cooperate to bring to an end any serious violations of parental norms entails the duty within the Security Council, in particular, entails the duty to not prevent, hinder, or delay collective action in favour of the peaceful resolution of the conflict. Mr. President, let me move on now to consider the two particular duties included in Article 41, paragraph 2 of the 2001 draft articles, namely the duty not to recognise the illegal situation and the duty not to render aid or assistance in maintaining this situation. What situation? The last resolutions adopted by the Security Council and the General Assembly on the Israel-Palestinian conflict update the scope of the current situation that should not be legally recognised. Certainly, Resolution 7488 of the General Assembly, the first one, including this formula, calls upon all states not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, including those aimed at advancing annexation in the occupied Palestinian territory. Since these two obligations have been reiterated by the Court and other United Nations bodies in this, but also in other situations, they are to be considered as customary law, something that, by the way, the International Law Commission has already affirmed. Finally, let me, Mr. President, to refer briefly to paragraph 3 of Article 41 of the draft articles, which states that international law may recognise additional legal consequences deriving from the legal regime to which the primary rule that has been violated belongs. These particular obligations can be found either in the foundation of the legal regime in particular or Security Council resolutions. Article 47 and 146 of the Fourth Geneva Convention are good examples of obligations provided for in the foundational treatise of a concrete, a particular legal regime like the international humanitarian law. While Article 47 establishes the inviolability of the rights of persons in occupied territories, Article 146 refers to the obligation of the states parties to the Convention to prosecute and condemn persons who commit or order to be committed any of the grave breaches of the Geneva Convention. As said, sometimes these obligations linked to a particular legal regime sometimes are specified by the Security Council itself. This is the case of Resolution 2334 of 2016, which requires the states to distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. Mr. President, distinguished members of the Court, Spain formulates these considerations within the framework of a consultative procedure, aware that the Court, guardian of international legality, can offer the United Nations arguments to adopt decisions to address the situation and, at the same time, contribute to the clarification and development of the international legal order. Thank you very much.
I thank the delegation of Spain for its presentation. I invite the next participating delegation, Fiji, to address the court and call upon Mr. Filippo Tarakinikini to take the floor.
Mr. President and esteemed members of the International Court of Justice, it is my great honor to appear before you today on behalf of the Republic of Fiji. Mr. President, for many decades, Fiji has built a tradition of peacekeeping. Our commitment to world peace is unwavering, and we are resolute in our efforts to contribute to global stability. I have personally had the privilege of leading peacekeeping operations in the Middle East over a period of more than 20 years. Mr. President, members of the Court, Fiji supports all efforts to establish a comprehensive, just, and lasting peace for both Israelis and Palestinians. Efforts that recognize the right of Palestinian people to self-determination and the right of the Jewish state of Israel to exist as a sovereign state with secure borders. Efforts that emphasize the need for the parties to engage in constructive negotiations as envisaged by the Security Council and the General Assembly. Fiji affirms the important role of this court as the highest judicial organ of the United Nations in resolving disputes between states and assisting UN organs in their activities. In so doing, the Court must promote the purposes and principles of the United Nations Charter. According to Article 1 of the UN Charter, one of the main purposes of the United Nations is, and I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, end of quote. Fiji strongly believes that the only way to achieve truly sustainable peace between Israel and the Palestinian people, indeed between any neighbors, is through mutual respect. As reflected in our written statement, Fiji considers it essential to maintain and uphold
the legal framework agreed between the parties and sanctioned by the Security Council to resolve the Israeli-Palestinian dispute. That framework is founded on the understanding that Jews and Arabs must coexist in a small piece of territory. This requires direct negotiations between the parties for an agreed outcome. Mr. President, members of the Court, the General Assembly has requested the Court to answer certain questions that focus on the legal consequences of the policies and practices of only one party to this dispute. To answer these questions, the Court would need to carry out an independent judicial assessment of both the law and the facts on virtually every aspect of the Israel-Palestine dispute, taking account of the relevant context. This is not an easy task. As Judge Higgins noted in her separate opinion in the Wall Advisory Opinion, and I quote, "The law, history, and politics of the Israel-Palestine dispute is immensely complex," end of quote. Further, context is usually important in legal determinations. In Fiji's view, this court has unfortunately been presented in these proceedings with a distinctly one-sided narrative. This fails to take account of the complexity of this dispute and misrepresents the legal, historical, and political context. In its written statement, Fiji has provided several reasons why the court should exercise its judicial discretion not to render an advisory opinion on the questions that have been posed by the General Assembly. First, the request is a legal maneuver to circumvent the existing internationally sanctioned and legally binding framework for resolution of the Israel-Palestine dispute. Second, to give an opinion in this case, and I quote, would have the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent, end of quote. And third, due to the one-sided formulation of the questions posed in Resolution 77/247, the Court does not have before it the accurate and reliable information that it would need to render an opinion on the questions posed. Mr. President, members of the Court, in this oral presentation, I will address the first and third of these issues. I turn to the existing framework. In these proceedings, the Court has been asked to render an advisory opinion that may well mean, in effect, the immediate, unconditional, and total end to the occupation. That is, withdrawal of all Israeli military, civilians from the entirety of the West Bank, East Jerusalem, and Gaza. This withdrawal must not only be complete, but it must also be unconditional. In other words, Israel may not impose or require any limitations or conditions. This unconditionality is supposedly necessary in order that the Palestinian people have a sovereign state on such territory, which they assert is the only way to achieve justice and therefore peace. Fiji respectfully submits that this demand of a complete and unconditional withdrawal circumvents the peace process and the agreements that have been made in pursuit of that process. Mr. President, the fact is that from 1993, Israel and Palestine entered into the series of agreements known collectively as the Oslo Accords. The parties expressed the intention to, and I quote, put an end to decades of confrontation and to live in peaceful coexistence, mutual dignity and security, while recognizing their mutual legitimate and political rights, end of quote. To that end, they agreed on a wide range of interim measures pending the achievement of a final agreement through permanent status negotiations. Some of those interim measures include the Palestinian Authority was established. Powers and responsibilities were transferred from the Israeli military government and its civilian administration to the Palestinian Authority, while Israel continued to exercise powers and responsibilities not so transferred. Direct, free and general political elections were to be held by the Palestinians. The West Bank was divided into 3 areas, A, B and C. The Palestinians would obtain exclusive control over Area A. Area B would be under joint Israeli-Palestinian control, and Area C would be under exclusive Israeli control. Lastly, the parties would enter negotiations on the permanent status to resolve the remaining issues, which included settlements, borders, Jerusalem, and security. In addition, the Oslo Accords contain a specific dispute resolution mechanism and do not permit either party unilaterally to commence or ask others to commence external legal proceedings. Since 1993, an extensive set of arrangements have been put in place to operationalize the agreements. In 2003, the General Assembly endorsed the Oslo Accords, and the Security Council has, and I quote, endorsed the Quartet performance-based roadmap to a permanent two-state solution to the Israeli-Palestinian conflict, end of quote. This court itself confirmed the importance of the Oslo Accords and the roadmap in the Wall Advisory Opinion in 2004. According to the roadmap, and I again quote, a two-state solution to the Israeli-Palestinian conflict will only be achieved through an end to the violence and terrorism. When the Palestinian people have a leadership acting decisively against terror and willing and able to build a practicing democracy based on tolerance and liberty, and through Israel's readiness to do what is necessary for a democratic Palestinian state to be established, and a clear, unambiguous acceptance by both parties of the goal of a negotiated settlement, end of quote. The thrust of the Oslo Accords and the roadmap is mutual performance and good faith negotiation leading to a consensual outcome. The Oslo Accords are legally binding. Remarkably, the Palestinians do not refer to these agreements in their written statement, while less than 12 months ago, both Israel and the Palestinians reaffirmed their, and I quote again, unwavering commitment to all the previous agreements between them, and to address all outstanding issues through direct dialogue, end of quote. Mr. President, it is our submission that the request to this court to opine on questions that address the legal obligations of only one party to this dispute conflicts with the clear rights and obligations of both parties in the Oslo Accords and the roadmap, and which exclude recourse to this court. For this reason, Fiji respectfully submits that the court should exercise its discretion not to render an opinion on those questions. Mr. President, members of this honourable court, I now turn to the issue of legal and factual evidence. As stated, in Fiji's view, the court should decline to answer the questions posed. But were it to do so, it would need to gather and independently assess the probative value of evidence on issues raised within the established legal framework of the dispute. This court would have to decide, as it has previously explained, and I quote, whether it has before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon any disputed questions of fact, the determination of which is necessary for it to give an opinion in conditions compatible with its judicial character." End of quote. In Fiji's view, the court cannot simply defer to the reports of United Nations bodies. In order to fulfill its judicial function, the court must reach its own independent findings of fact. Further, Fiji submits that due to the selective and one-sided formulations of the questions, the court does not have before it all the evidence it would need to exercise its judicial function. Mr. President and members of the esteemed members of the court, the point here is that the court is being asked to focus solely on the policies and practices of one of the parties to this dispute, to the exclusion of the policies and practices of the other. This is highly problematic. If the court would limit itself to consideration of the questions asked, it would be unable to consider the relevant broader context, and it will also not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon questions of fact that are in dispute, all of which would be necessary to give an opinion compatible with its judicial character. We will illustrate this by looking briefly at three of the issues raised by the questions that have been posed to the court. And these are withdrawal and security, territorial sovereignty, and the right to self-determination. First, withdrawal and security. Palestine argues that the occupation is illegal, and the legal consequence is that Israel must withdraw from the occupied territories. As highlighted earlier, any assessment of the questions posed would require the court to consider the legal rights and obligations of both parties under the Oslo Accords. The Oslo Accords were built upon Security Council Resolution 242 and 338, which were adopted following the 1967 and 1973 Arab-Israeli wars. They recognize the legitimate security needs of Israel to prevent further attack. Resolution 242 and 338, and thus the Oslo Accords, do not oblige Israel to withdraw from all the territories. Further, Resolution 242 and 338 refer to peace being established by the application of two mutually dependent principles, and I quote, "First, withdrawal of Israeli armed forces from the territories occupied in the recent conflict, and two, termination of all claims or states of belligerency and respect for and acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area, and their right to live in peace within secure and recognized boundaries, free from threats or acts of force." End of quote. By incorporating these resolutions into the Oslo Accords, the parties recognize that Israel's withdrawal and the creation of conditions providing security to Israel are interdependent. As Judge Higgins stated in the Wall opinion, both, and I quote, "Israel and Palestine need to move in parallel to secure the necessary conditions for Israel to withdraw from Arab-occupied territory and for Palestine to provide the conditions to allow Israel to feel secure in so doing." End of quote. In other words, if the court is to consider the legal consequences of the alleged Israeli refusal to withdraw from territory, it should also look at what Palestine must do to ensure Israel's security. Mr. President and members of this honorable court, the events of 7 October 2023 have shown us what could happen if there were a complete and unconditional withdrawal without the necessary arrangements in place to guarantee the security of Israel and its population. At the very least, the court would need to examine and evaluate evidence concerning the question whether the 1949 armistice lines are secure boundaries within the meaning of Resolution 242 and 338. This in turn would require examination of the threats facing Israel emanating from the occupied territories and the broader region. Second, territorial sovereignty. Mr. President and members of the Court, the General Assembly's request speaks of Israel's, and I quote, prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, end of quote. This asks the Court to presuppose that all the territories held during the Jordanian and Egyptian occupation within the 1949 armistice lines are Palestinian. That is, that they are sovereign territories of Palestine and thus not of Israel. A precise definition of the scope of territorial claims is important because, and I quote, territorial sovereignty is a fundamental principle of the international political and legal order. It serves to divide between nations the space upon which human activities are employed in order to assure them at all points the minimum of protection of which international law is the guardian. End of quote. In the context of the questions put to this Court, territorial sovereignty is critical because without clarifying the respective claims of Israel and the Palestinians concerning the sovereign status of the territory, it would be impossible to answer the questions of territorial scope of the Palestinian self-determination claim or the occupation. Fiji notes that the question of territorial scope, both of the State of Israel and of the self-determination claim of the Palestinian people, is in dispute between the parties. And yet, the way the questions are drafted excludes the possibility of the Court considering Israel's claims to the sovereignty over the territory and asks the Court to assume, without further investigation, that these territories are somehow Palestinian. Furthermore, the Court would need to assess whether the Palestinians have sovereignty, and if so, over which territory. This would include an examination, among other things, of the history of the Palestinian assertions of claims and of where the Palestinians make different assertions of sovereignty in different fora. Palestine asserts that the provisions in the mandate for Palestine concerning the establishment of a Jewish homeland as envisaged in the Balfour Declaration were illegitimate and in contravention of the Covenant of the League of Nations. It appears to claim that all the territory of Mandate Palestine, even including what is generally accepted to be the territory of the State of Israel, belongs to the Palestinian people. Mr. President, Israel asserts, and Fiji agrees, that the mandate for Palestine, including its provisions concerning the establishment of the Jewish homeland, such as the right of the Jewish people to live in and closely settle the land, was a binding instrument of international law. Israel also argues that the relevance of the rights conferred by the mandate for Palestine was affirmed in Article 80 of the UN Charter, the so-called Palestinian Clause. There is thus a dispute about territorial sovereignty. Fiji submits that this dispute cannot and should not be resolved through means of the requested advisory opinion for two reasons. The first reason is that the question of borders and therefore the scope of territorial sovereignty was expressly agreed to be resolved through the permanent status negotiations to which the parties have committed themselves in the Oslo Accords. For the reasons set out earlier, this precludes the matter being adjudicated via an advisory opinion procedure. The second reason is that, in any event, because of the way the questions to the Court have been formulated, the Court simply does not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion on the disputed issue of the geographic limits of the territorial sovereignty of Palestine and Israel. I now turn to self-determination. The questions before the Court ask you to assume that Israel is violating the right of the Palestinian people to self-determination. The question of self-determination raises the question of territorial scope. This raises the evidentiary concerns I have just expressed. Moreover, Fiji knows that the right to self-determination is a relative right. It should not involve changes to existing frontiers. In the context of Israel Palestine, this means that the court would need to ascertain whether the Palestinians' exercise of their right to self-determination has infringed the territorial integrity, political inviolability, or legitimate security needs of the State of Israel. By asking the court to look only at the policies and practices of Israel, Resolution 77/247 shields from the court's purview the policies and practices of Palestine. The result in Fiji's submission is that the court simply does not have before it sufficient information concerning the policies and practices of Palestine, and thus is unable to make a judicial determination on whether, in exercise of their right to self-determination, Palestine has infringed the sovereignty of the State of Israel. Mr. President, esteemed members of the court, in conclusion, the relationship between Israel and the Palestinian people is legally, factually, and historically complex. There are no simple answers. But there are two parties who need to jointly find a solution, and they should be supported to do this. Using the advisory opinion procedure to prosecute the alleged violation of international law of one of the parties to the dispute while ignoring possible violations by the other will not promote dialogue nor foster mutual respect. Rather, it is likely to undermine efforts towards peace that can be best settled through the recommitment of the parties to the processes established under the Oslo Accords. In our view, this is why the General Assembly was seriously divided on whether this question should be put to the court for an advisory opinion. And it is also why this honourable court should refrain from giving one. Fiji respectfully submits that for all these reasons, the court should exercise its judicial discretion to decline to provide an advisory opinion on the specific question put to it in the UN General Assembly Resolution 77/247. Mr. President, were the court to decide to provide an advisory opinion, which Fiji submits it should not, the court should be cautious to ensure the advisory opinion rendered does not circumvent the binding agreements between the parties, but encourages them to promote fruitful negotiations. Furthermore, the court should ensure that it does not impose obligations and responsibilities on only one party while disregarding its legitimate concerns. Mr. President, members of this honourable court, this brings me to the end of Fiji's oral presentation, and I thank you.
I thank the delegation of Fiji for its presentation. I now call upon the delegation of the Maldives to address the court and invite Her Excellency Ms. Shakir to take the floor.
Mr. President, members of the court, I have the honor to appear before you on behalf of the Republic of Maldives, a state staunchly committed in upholding international law. Support for the Palestinian people, including their pursuit of an independent sovereign state of Palestine, has been a long-standing cornerstone of the Maldives foreign policy and remains so under the government of President His Excellency Dr. Mohamed Muiz, who took office in November 2023. There are no compelling reasons not to exercise jurisdiction. To the contrary, the dire humanitarian crisis unfolding in Gaza reminds us all that this is a historic opportunity for the court to pronounce its verdict on the grave injustices that have been long perpetrated against the Palestinian people. The Maldives oral submissions today will come in two parts. Ms. Amy Sander will first address the court on Israel's multiple serious violations of international law in the occupied Palestinian territory, focusing on its practices in relation to water resources. Following this, Dr. Naomi Hart will provide concise answers to the two questions which the General Assembly has requested that the court answer. Before concluding, I would like to once again reiterate our firm belief that the only sustainable solution to the conflict is the establishment of a sovereign and independent state of Palestine based on the pre-1967 borders with East Jerusalem as its capital. Mr. President, members of the court, I thank you for your attention and ask that you give the floor to Ms. Sanders.
I thank Her Excellency Ms. Shakir. I now give the floor to Ms. Amy Sanders. You have the floor, Madam.
Mr. President, members of the court, representing the final state appearing, I have the honour of identifying the main points addressed during the course of this hearing on the violations by Israel of international law. The Maldives provides this analysis with a focus on the issue of water resources. Why? Because of two streams of significance. First, the significance of water resources to the Palestinian people. In fact, it has been described as the most vital resource in the occupied Palestinian territory by Palestine. A tidal wave of suffering has been unleashed by Israeli policies and practices with respect to water resources, which are characterized by deprivation, denial, discrimination and destruction. Deprivation of access to water. Many Palestinians in the Gaza Strip simply have, I use the court's own words, no access to potable water. Denial of enjoyment of those resources on a discriminatory basis. In the West Bank, where Israel has seized control of water resources, use of vital groundwaters is marred by grossly inequitable allocations between Israelis and Palestinians. Destruction of vital infrastructure, with Israel demolishing sanitation structures and pipelines. The second stream of significance is to the questions before the court. The issue of water resources flows through four key aspects of the unlawfulness of Israeli policies and practices on which the oral submissions have focused, and I address each aspect in turn. The first key aspect, the violation of the right of the Palestinian people to self-determination. The following points are crystal clear. First, the Palestinians are a distinct people with a right to self-determination, an inalienable norm of Jus Cogens. Second, Israel's conduct has violated different components of that right, notably the right to territorial integrity, the right not to be subjected to demographic manipulation within that territory by a foreign power, the right of the people to pursue its chosen economic, social and cultural development, and its right to exercise permanent sovereignty over its natural resources. And the critical importance of this well-established latter component, the Palestinian people's right to exercise permanent sovereignty over their natural resources, was recently stressed by the General Assembly in its resolution of December 2023. Such resources clearly include water. Israel's policies and practices with respect to water resources, the deprivation, denial on a discriminatory basis, and destruction, thus constitute one acutely serious and ongoing facet of the breach of the Palestinian people's right to self-determination, described by our UN body as one of the most fundamental conditions for survival. For a people, sufficient clean water is indispensable. Turning to the second key aspect, the policies and practices of Israel in the occupied Palestinian territory violate the prohibition of the acquisition of territory by force. This afternoon, we have heard some attempts to muddy the waters in this regard, so I will recall the points of crystal clarity. First, a corollary of the Jus Cogens prohibition of use of force is the prohibition of any acquisition of territory by threat or use of force, irrespective of international recognition of Palestine's borders. The applicability of this prohibition to the occupied Palestinian territory cannot be in doubt, as expressly recognised in resolutions of both the General Assembly and Security Council. Second, international law requires that occupation be temporary. Third, any purported exercise of the use of self-defence must be necessary and proportionate. Fourth, and flowing from the three previous points, an occupying power cannot acquire sovereignty over an occupied territory, including by annexation, irrespective of whether it claims to have acted in self-defence at any point during the occupation. Yet Israel has annexed all of the occupied Palestinian territory, whether through Israeli law or conduct manifesting a de facto annexation, creating a fait accompli. And there's no shortage of evidence on this reality, as emphasised by many UN bodies and demonstrated by the map recently shown by the Prime Minister of Israel before the General Assembly, referred to on the first day of this hearing. Israel's deprivation, denial on a discriminatory basis, and destruction with respect to water resources is one facet of this annexation. The scale and nature of Israel's conduct in this regard makes clear that it forms an integral element of Israel's establishment of control through coercive measures, reflecting its intention to appropriate that territory permanently. The occupation having, to quote the Special Rapporteur, burst through the restraints of temporariness long ago. Israel's settlement expansion is plainly another integral element of that annexation, with Palestinians reduced to inhabiting a fragmented archipelago of disparate patches of land. Of course, the different aspects of Israel's violations of international law are not watertight from one another. Such prolonged occupation, annexation, and settlement expansion also violate the right of self-determination to which I referred earlier, a right which cannot be exercised in the face of a foreign occupier purporting to appropriate territory for itself and thereby dispossess the Palestinian people. The third key aspect is that the policies and practices of Israel in the occupied Palestinian territory violate the law of occupation. The indisputable starting point is that, as an occupying power, Israel is bound to respect, throughout the occupied territory, its obligations under international humanitarian law, a regime designed to ensure the protection of the people under occupation. And the Maldives agrees that the continuing applicability of international humanitarian law is without prejudice to the unlawfulness of Israel's occupation. Now, many examples of international humanitarian law breaches have been cited before the court, including with respect to Israel's settlement policy as a breach of Article 49 of the Fourth Convention. Israel's policies and practices with respect to water resources constitute a cascade of further violations of the Fourth Geneva Convention and the 1907 Hague Regulations. Notably, Israel's conduct is a violation of the rules prohibiting destruction of property, which includes water and sanitation infrastructure, in circumstances where it is clearly not absolutely necessary for military operations. It's a violation of the prohibition on destruction or removal of objects essential for survival of the civilian population, with water installations and supplies obviously qualifying as such. It's a violation of the prohibition on pillage, as well as the rules of usufruct. It's also a violation of the obligation to ensure and maintain public health and hygiene in territory it occupies, And this goes to a point of grave practical concern. A raft of horrific diseases spring directly from the lack of clean water, with little children particularly vulnerable. The fourth and final key aspect is that Israel's policies and practices in the occupied territory are in violation of international human rights law, including the fundamental Jus Cogens prohibition of discrimination. The irrefutable starting point. This is that Israel bears a duty to secure respect for the applicable rules of international human rights law throughout the territory that it occupies. International human rights law encompasses the right to water. Notably, that right emanates from Articles 11 and 12 of the International Covenant on Economic, Social and Cultural Rights. As the General Assembly affirmed in 2016, the human rights to safe drinking water and sanitation as components of the right to an adequate standard of living are essential for the full enjoyment of the right to life and all human rights. Further, as a party to the Convention on the Rights of the Child, Israel has expressly undertaken to pursue full implementation of each child's rights to the enjoyment of the highest attainable standard of health, including through the provision of clean drinking water. Equally clearly, international human rights law prohibits discrimination. Notably, pursuant to the Convention on the Elimination of All Forms of Discrimination, Israel is obliged to prohibit and to eliminate racial discrimination in all its forms and to guarantee the right of everyone, without distinction as to race, colour, national or ethnic origin, to the enjoyment of rights, which include a right to water. Yet Israel's discriminatory policies and practices with respect to access to water have been well documented and condemned by a deluge of UN bodies, with the Committee on the Elimination of Racial Discrimination, I quote, appalled at the hematic character of the separation of two groups, Jewish communities in illegal settlements on the one hand, Palestinian populations, on the other hand, who do not enjoy equal access to water resources. The impact on women and children is notably egregious, with the dearth of clean water an acute crisis for mothers trying to feed their babies. Israel's policies and practices relating to water are but one among many examples of systematic discrimination which have been detailed by other states in these proceedings. And the Maldives joins the plethora of other states in confirming before this court that the regime which Israel has established throughout the occupied territory constitutes apartheid, pursuant to the customary international law definition as reflected in Article 2 of the Apartheid Convention. Mr. President, members of the court, at a human level, Israel's policies and practices with regard to water resources are inexcusably intensifying the hardship being endured by the Palestinian people and exemplify the illegality which has characterized Israel's occupation. The final speech for the Maldives will address how the court should answer the questions posed by the General Assembly in light of Israel's breaches of international law. Mr. President, I thank you for your kind attention, and I invite you to call Dr. Hart to the bar.
I thank Ms. Sander. I now give the floor to Ms. Naomi Hart. You have the floor, madam.
Mr. President, members of the court, against the backdrop of Palestinians' extraordinary human suffering cast in vivid relief this past week, the court's function is to provide advice to the General Assembly on the two legal questions posed to it. It is my honour, on behalf of the Maldives and as the final speaker in these proceedings, to provide succinct, direct responses to those two questions. Question A asks the court to opine on the legal consequences of Israel's ongoing violation of the Palestinian people's right to self-determination, its prolonged occupation, settlement and annexation of the occupied Palestinian territory, and its discriminatory legislation and measures. The states appearing before you have been largely consistent on this question, and that is unsurprising because the relevant principles are well established in the customary international law rules on state responsibility and the court's jurisprudence. First, Israel is obliged to cease its continuing unlawful acts. This includes, of course, an obligation to terminate its occupation, just as South Africa was obliged to withdraw from Namibia, where its presence was illegal. The court there specifically stated that withdrawal must occur immediately. Here, the General Assembly has recently stressed the urgency of achieving without delay an end to the Israeli occupation. But that is not all. Israel must also cease the discrete unlawful practices which have characterised its occupation. For example, it must dismantle the discriminatory regime concerning water resources referred to in Ms. Sanders' speech. In precisely the same way as the court previously stated that Israel must dismantle both the wall and the associated legislative and regulatory regime which entrenched discrimination. Secondly, at the same time as terminating its unlawful acts, Israel must provide assurances that it will not repeat them. Thirdly, Israel is obliged to provide comprehensive reparations. Restitution is optimal as far as possible, but you heard from Palestine last Monday that no action by Israel now could ever restore the Palestinian people to the situation which would have existed without its violations. In that case, Israel's reparations must include compensation. And to the extent that compensation will not fully make good the harms caused, Israel must provide just satisfaction in other forms, such as acknowledging its breaches and providing formal apologies. Fourth, there are obligations on third states. States parties to the Fourth Geneva Convention must search for individuals accused of committing or ordering grave breaches of that instrument and prosecute, including the rules of occupation, and prosecute or extradite them. Further consequences flow from the occupation's unlawful status, and I will deal with those in relation to the second question. In question B, the General Assembly asked the court how Israel's policies and practices in the occupied Palestinian territory affect the legal status of the occupation and what legal consequences arise for all states and the United Nations. Ms. Sander has addressed the many illegal aspects of Israel's occupation. Each and every one of Israel's unlawful acts engages its responsibility as a state. But what is it that determines the status of the occupation? The factors affecting status are those that go beyond illegality in the conduct of the arbitration and that make the occupation irremediable, meaning that the occupation is what the court described in the Namibia opinion as a situation which is maintained in violation of international law. In other words, it is those breaches of international law that cannot be cured within the occupation, but only by the occupation coming to an end, that render it unlawful as a matter of status. One such matter is the permanence of Israel's occupation, notably the fait accompli that this court warned about in its Wall opinion. Israel has sought to create irreversible facts on the ground. As Ms. Sander has highlighted, by installing itself as an interminable presence, Israel has violated the prohibition on acquisition of territory by force. The court need not decide whether Israel's occupation was unlawful ab initio. Its wrongfulness can be established even if one looks only at the fact of its prolonged continuation with no end in contemplation. The wrongful permanence of Israel's presence, that breach of a peremptory norm of international law, cannot be corrected for as long as Israel remains in the occupied territory at all. That is why it goes to the occupation's status. The same is true when it comes to Israel's breaches of the right to self-determination. For example, that right encompasses an entitlement to territorial integrity, whether or not the territory is within internationally recognised borders, contrary to what you have been told this afternoon. It is inherent in Israel's ongoing occupation that it dispossesses Palestinians of their territory and that it divides the territory. Recall the fragmented archipelago that Ms. Sander referred to. Israel's presence and the Palestinian people's right to territorial integrity are mutually exclusive. And again, this is determinative of the occupation's status. What are the legal consequences of this analysis? For Israel, they include those I have already addressed in relation to question A, starting with the duty immediately to terminate the occupation in its entirety. Given the occupation's unlawful status, Israel simply cannot achieve compliance with international law as long as it remains in occupation. As well, Israel's ongoing presence cannot produce any effects as a matter of international law, and in particular, cannot change the status of any occupied territory. However, as Ms. Sander has alluded to, it is not a consequence of the occupation's status that Israel can somehow escape obligations concerning the conduct of an occupation. To the contrary, pending its urgent withdrawal, Israel remains bound by rules of international humanitarian law. Those rules apply whenever an occupation exists in fact, lawful or not, and as the court has stated, regardless of the status of the occupied territories. The same is true of Israel's obligations under international human rights law. Those duties are engaged based on Israel's exercise of jurisdiction, again, a purely factual state of affairs. The conduct of third states and the United Nations is likely to be of critical practical importance in leading Israel to end its unlawful actions. The people of Palestine, like the people of Namibia half a century ago, should be able to look to the international community for assistance in realising their rights. In light of Israel's gross and systematic breaches of Jus Kogan's norms, third states bear certain negative duties articulated in the court's previous advisory opinions. They must not recognise the situation created by Israel's occupation as lawful or lend that occupation any support or assistance. Accordingly, they must avoid acts which could imply such recognition, such as engaging in trade or any other forms of relationship with Israel, which may entrench its position. They also must not enter into or maintain treaty relations in which Israel purports to act on behalf of or concerning that territory, except treaties of a humanitarian character. Third states must not send diplomatic or special missions to Israel with a remit extending to the occupied territory, as if that territory was simply part of Israel. A third state which does not uphold these duties may encounter consequences in its own relations with other states. According to the court in Namibia, no state which enters into relations with South Africa concerning Namibia may expect the United Nations or its members to recognise the validity or effects of such relationship. The same applies here. Equally, third states bear certain positive duties, an obligation to cooperate, including through the United Nations, to complete Israel's extraction from the occupied territory, a duty to remove any impediments to the Palestinian people's exercise of the right to self-determination, and a duty to ensure Israel's compliance with international humanitarian law. As for the United Nations, all of its component parts, but especially the General Assembly and the Security Council, should consider what further action is required to bring to an end the illegal situation. In 2004, the Court urged the United Nations, as a matter of urgent necessity, to redouble its efforts to bring the Israeli-Palestinian conflict to a speedy conclusion. That urgency has not abated. It has intensified. How the Court advises the General Assembly on this occasion will, it is to be hoped, help to illuminate the path forward for the entire United Nations system. Mr. President, distinguished members of the Court, that concludes the submissions of the Maldives.
I thank the delegation of the Maldives for its presentation. This presentation concludes the oral statements by all the participants who have expressed a wish to participate in the present oral proceedings. It also brings to a close the hearings on the request for advisory opinion submitted by the General Assembly of the United Nations regarding the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. I would like to convey the Court's thanks to all the delegations who have addressed it in the course of these 6 days, as well as to the participants in the written proceedings. I would also ask the representatives of all participants to remain at the disposal of the Court in case it should require any further information or explanations from them. The Court will now retire for deliberation. The Registrar will, in due course, inform all the participants and all members of the United Nations General Assembly of the date and time when the Court is to render its opinion. As the Court has no other business before it today, I declare this sitting closed.